Article 4, Section 1 of the Constitution. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings. To judicial acts, public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or another crime, who shall flee from justice and be bound in another state, shall be on demand of the executive authority of the state from which he fled, be delivered up, to be removed to the state having jurisdiction of the same. No person held to service or labor in one state under the laws thereof, escaping into another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered up on the claim of the party to whom such service or labor may be due. Section 3 of Article 4. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states. Keep in mind the definition of state in law, as we keep saying state, as far as not in the boundaries of the Union states. Or parts of a state without the consent of the legislators of the states concerned, as well as the Congress. The Congress shall have power to dispose of and make all needful rules, regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. The United States or any particular state. Section 4. The United States shall guarantee to every state in this union a Republican form of government, and shall protect each of them against invasion and on application of the legislator or of the executive, when the legislator cannot be convened against domestic violence. So we just read Article 4, Section 1 through 4. So now we're going to dissect what we just read. So back to the language of Article 4, right? We got full faith and credit, entitled, right? General law. So this is all the lingo, judicial proceedings. So now we're going to break down Article 4 with law definitions so you get competency on the terminology for further clarity. Law definition of full faith and credit. Full faith and credit clause of Constitution, U.S. Article 4, Section 1. We got to read that. This is a definition in the Law Dictionary, 4th edition. Requires that foreign judgment be given such faith and credit as it had by law or usage of state of its origin. Case law to support that, National Bank versus Terry. The foreign statutes are to have force and effect to which they are entitled in the home state. Case law to support that, Lehigh versus Missouri. And that a judgment or record shall be the same faith, credit, conclusive effect, and obligatory force in other states as it has by law or usage in the state from whence taken. Case law to support that, Christmas versus Russell, Pennsylvania Fire Institute of Philadelphia versus Gold Issue Mining and Mill Company. Law definition of credit. a sum credited on the books of a company to person who appears to be entitled to it. Kuhn versus Home Life Institute. The credit of an individual is the trust reposed in him by those who deal with him that he is of ability to meet the engagements, and he is trusted because through the tribunals of the country he may be made to pay. The credit of a government is founded on a belief of its ability to comply with its engagements and a confidence in its honor that it will do that voluntarily, which it cannot be compelled to do. Case law to support that, Owen versus Branch. Judicial proceedings. The law definition of judicial proceedings. Any proceedings wherein judicial action is invoked and taken. Case law to support that, Mannix versus Portland Telegram. Any proceedings to obtain such remedy as the law allows. Traylor versus Harris. Any step taken in a court of justice in the prosecution of a defense of an action. National Homestead Association versus Graham. Still dealing with the definition. A general term for proceedings related to practice in or proceeding from a court of justice, or the course prescribed to be taken in various cases for the determination of a controversy, or for legal redress or relief. Case law to support that, Barton versus Simpkins. Mullen versus Reed. Aldridge versus Kinney. A proceeding in a legally constituted court, a proceeding wherein there are parties who have opportunity to be heard, and wherein the tribunal proceeds either to a determination of facts upon evidence or of law upon proved or concealed facts. Judicial proceeding, right? Res judicata. Everything I'm reading in judicial proceedings is res judicata, stare decisis. In another language. It's another way of saying that. Law definition of general law. A law that affects the community at large. A general law as contradistinguished from one that is special or local is a law that embraces a class of subjects or places and does not omit any subject or place naturally belonging to such class. Case law to support that, Van Riper versus Parsons, Mathis versus Jones, Brooks versus Hyde. Still dealing with general law. A law framed in general terms, restricting to no locality and operating equally upon all of a group of subjects, which having regard to the purposes of the legislation are distinguished by characteristics sufficiently marked and important to make them a class by themselves, is not a special or local law, but a general law. Case law to support that, Jones versus Power County, Scarborough versus Wooten, Toombs versus Sharkley. The law definition of entitled. In its usual sense, to entitle is to give a right or title. To qualify for, to furnish with proper grounds for seeking or claiming. In ecclesiastical law, entitle is to give a title or ordain a nation as a minister. Law definition of privileges. A particular and peculiar benefit or advantage enjoyed by a person, company, or class beyond the common advantages of other citizens. An exception or extraordinary power or exemption. A right, power, franchise, or immunity held by a person or class against or beyond the course of the law. Waterloo, Water Company versus Village Waterloo. and others. An exemption from some burden or attendance with which persons are indulged from a supposition of law that the stations they fill or the offices they are engaged in are such as require all their time and care, and that therefore, without this indulgence, it would be impractical to execute such offices to that advantage which the public goods require. In case law to support that. Still dealing with privileges. That which releases one from the performance of a duty or obligation or exhibits one from a liability which he would otherwise be required to perform or sustain in common with all other persons. Case law. A peculiar advantage, exemption, or immunity. So now we're dealing with just general, the law definition of general. Privilege from arrest. A privilege extended to certain classes of persons, either by the rules of international law, the policy of the law, or the necessities of justice, or of the administration of government, whereby they are exempted from arrest on civil process, and in some cases on criminal charges, either permanently, as in fourth case of a foreign minister in his suit, or temporarily, as in the case of the members of the legislature, parties, and witnesses engaged in a particular suit, etc. So they're distinguishing international matters, which would be dealing with nationals, from in-house processes. Immunity, law definition of immunity, or immunities with the suffix. Exemption, as from serving in an office or performing duties which the law generally requires other citizens to perform. Case law to support. Freedom from duty or penalty. Case law to support. The term aptly describes an exemption from taxation. Buchanan versus Knoxville and others to support that. Law definition of treason. And once again, we're going through definitions with a fine-tooth comb of certain lingo that was in Article 4 of Section 1. Treason, the offense of attempting by overt acts to overthrow the government of the state to which the offender owes allegiance, or by betraying the state into the hands of a foreign power. Treason consists of two elements: adherence to the enemy and rendering him aid and comfort. Kramer versus US to support that. Law definition of felony. A crime of a graver or more atrocious nature than those designated as misdemeanors. Case law. Generally an offense punishable by death or imprisonment in penitentiary. Case law. And at common law, an offense occasionally total forfeiture of either land or goods to which capital or other punishment might be the superadded according to degree or guilt. Law definition of jurisdiction. The word is a term of large and comprehensive import and embraces every kind of judicial action. Federal Land Bank of Louisiana versus Crombie and others to support that. It is the authority by which courts and judicial officers take cognizance of and decide cases. Board versus Board of Trustees of Firemen's Relief and Pension Fund of City of Marietta versus Brooks. Case law to support that. Still dealing with jurisdiction, the legal right by which judges exercise their authority. Case law to support that. It exists when courts have cognizance of class of cases involved, proper parties are present, and point to be decided. Point to be decided is within issues. So the judges are supposed to know classes of law, different citizenships, and what that means as far as, do they have territorial, do they have subject matter, do they have personam? These are things that they must know if that's right before they move on, based on the status of the human being in front of them. Case law to support that, Knox and Chemical Produce Company versus Lecky and others. Still dealing with jurisdiction. It is the authority, capacity, power, or right to act. Case law to support that, one of them, Industrial Addition Association versus Commissioner of the Internal Revenue, Tennessee, Supreme Court case, and others. Jurisdiction, carry into execution or enforce sentence, judgment, or decree. Compels parties to come before court or body. Case law to support. Deals with subject matter. We're dealing with jurisdiction still. It deals with subject matter, including questions of law, as well as a fact. We're dealing with jurisdiction. Declare, expound, administer, or apply the law. Dealing with jurisdiction and case law to support that. Law definition of territory. In Latin, terra, dealing with the earth, soil, arable land. Territory, a part of a country separated from the rest and subject to a particular jurisdiction. Territory in American law, a portion of the United States not within the limits of any state, which has not yet been admitted as a state of the Union, but is organized with a separate legislature and with executive and judicial officers appointed by the president. Case law to support. So they're saying they can set up states as long as they're not in the way of other states. So imagine if the Moors was woke and it was different body politics everywhere. We're boxing them in. Law definition of suffrage. Because I was the language in Article 4, Section 1. Suffrage, a vote, the act of voting, the right or privilege of casting a vote at the public elections. The last is the meaning of the term in such phrases as the extension of the suffrage, universal suffrage, etc. in case law to support. Participation in suffrage is not a right, but is granted by the state on a consideration of what is most for the interests of the state. The grant of suffrage makes it a legal right until it is recalled, and it is protected by law as property is. Back to Republican form of government. So anybody voting in any nation state was granted electoral power. For example, any board members in Khalifa Society, it was a vote for people to be board members in the first place. That's an example of what would be an electoral college in the United States world. So once again, if you're not in the electoral college of the United States and you think you're a US citizen, your vote doesn't count. They're just collecting data. Moving forward. And for reinforcement purposes is right here. Definition of state. A people permanently occupying a fixed territory bound together by common law, habits, and customs into one body politic, exercising through the medium of an organized government, independent sovereignty and control over all persons and things within its boundaries, capable of making war and peace, and of entering into international relations with other communities of the globe, of the whole world. When you're a national, you deal with other nationals on the planet. They're not dealing with Negroes. All right, so let me just go down to some questions that, once again, just like the questions from last Wednesday, ask yourself honestly, can I answer these questions? 1, what will full faith and credit be given to? Explain what that means. 2, who determines how the acts, records, and proceedings shall be proved, and the effect, if any? Identify the party. 3, what are the citizens entitled to? 4, what do you think it means when they say entitled to all privileges and immunities of citizens in the several states? No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Who do you think this is referring to, and why? And where is it referenced? 5, how are new states admitted into the Union? And who is Congress? 6, the quote, but new states shall be formed or erected within the jurisdiction. Let's rewind. The quote, but no new state shall be formed or erected within the jurisdiction of any other state. Please explain what this means. Is there a possible example of this violation today? Ask yourself, do you get what this is implying? And I lightweight talked about it like 5 minutes ago. 7, nor any state be formed by the junction of 2 or more states or parts of states without the consent of the legislators of the states concerned as well as the Congress. What does this reference today? 8, even the legislators of the states consent, who has final say so and must also consent. Who is the Congress? 9, who has the power to dispose of and make all needful rules and regulations as to the territory or other property belonging to the United States? What is territory? What does this tell you about the territory and other property? 10, what is guaranteed to every state in the Union? 11, what shall the states be protected from? Who is obligated to provide this protection? Who is the United States defined in the reference? Where is this defined? 12, how can the Constitution be amended? 13, provided that no amendment which may be made prior to the year 1888 shall in any manner affect the first and the fourth clauses of the ninth section of this first article. What does the first and the fourth clauses of the ninth section of the first article state? Can you give a brief explanation of what is being said, or what this is saying rather? So once again, ask yourself if you can answer these questions. And in summary, we're dealing with Article 4, Section 1, dealing with full faith and credit, right? To each state to public acts, records, and judicial proceedings of every other state, and we broke down the lingo, right? Right to a Republican form of government. All this is in Article 4. This will be Article 4, Section 4. Full faith and credit will be Article 4, Section 1. Okay. So I want to actually, since it's getting close to about an hour, cover as much as we can with Article 6. Once again, this is the actual article, and then we break down the analysis of terminology in the article. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws in any state to the contrary shall not be withstanding. The senators and representatives before mentioned and the members of the several legislators and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Now let's analyze Article 6, or analyze as much as we can before the hour mark. Law definition of debts. That was the language in Article 6. A sum of money due by certain and express agreement, as by bond for a intermediate sum, a bill or note, a special bargain, or a rent reserved on a lease, where the amount is fixed and specific and does not depend upon any subsequent valuation to settle it. Case law to support that. An unconditional promise to pay a fixed sum at a specific time. Case law to support that. A contractual obligation to pay in the future for considerations received in the present. Case law to support that. The word debt carries with it the requirement of certainty, the foundation of promise by express contract, and necessarily implies legality. Case law to support that. The word debt in the definition of a mortgage as a hypothecation or pledge of property as security for a debt means a duty or obligation to pay for the enforcement of which an action lies. Case law to support that. Standing alone, the word debt is as applicable to a sum of money which has been promised at a future day as to a sum of money now due and payable. To distinguish between the two, it may be said of the former that it is a debt owing, and to the latter that it is a debt due. A sum of money which is certainly a sum of money which is certainly is all events payable is a debt, without regard to the fact whether it be payable now or at a future time. A sum payable, a sum payable upon a contingency, however, is not a debt, or does not become a debt until the contingency has happened. And case law to support that. A sum of money arising upon contract, expressed or implied. Also, the obligation to pay a sum certain, or a sum which may be ascertained by simple mathematical calculation from known facts, regardless of whether the liability arises by contract or is implied or imposed by law. A debt is a specified sum of money owing to one person from another, including not only obligation of the debtor to pay, but the right of the creditor to receive and enforce payment. A fixed and certain obligation to pay money or some other valuable thing or things either in the present or in the future. Case law to support that. In a still more general sense, that which is due from one person to another, whether money, goods, or services. Case law to support that. A debt is an obligation arising otherwise than by sentence by a court for a breach of the public peace for a crime. Case law to support that. In a broad sense, any duty to respond to another in money, labor, or service. It may even mean a moral or honorary obligation, unenforceable by legal action. Case law to support that. Also, sometimes an aggregate of separate debts or the total sum of the existing claims against a person or company. Thus, we speak of the national debt, the bonded debt of a corporation, etc. The word debt has no fixed legal meaning. Case law to support that. But take shades of meaning from the occasion of its use and color from accompanying words. Case law to support that, Morrow versus Hayes. The word is of large import, including not only debts by speciality and debts of record or judgments, but also obligations arising under the simple contract to a very wide extent, and in its popular sense includes all that is due to a man under any form of obligation or promise. Synonyms. The term demand is of much broader import than debt and embraces rights of action belonging to the debtor beyond those which could appropriately be called debts. In this respect, the term demand is one of very extensive import. Case law to support that. Nevertheless, debt may be synonymous with claim and may include any kind of a just demand. The word dues is equivalent to debts or that which is owing and has a contractual significance. State versus Mortgage Security Company. Debt is not exactly synonymous with duty. A debt is a legal ability to pay a specific sum of money. A duty is a legal obligation to perform some act. Case law to support that, Allen versus Dickerson. Obligation is a broader term than debt. Case law to support that, Bovee versus Boyle. Every obligation is not a debt, though every debt is an obligation. Case law to support that. The words debt and liability are not necessarily synonymous as applied to the pecuniary relations of parties. Liability is a term of broader significance than debt. Poultry Dry Goods Company versus Wentworth. Liability is a responsibility, the state of one who is bound in law and justice to do something which may be enforced by action. This liability may arise from contracts, either express or implied, or in consequence of torts committed. Case law to support that. Liability ordinarily means an obligation which may or may not ripen into a debt. Case law to support that, Irving Bank Columbia Trust Company versus New York. Yet, debt may sometimes include various kinds of liabilities. More case law of another trust company, interesting. In general, active debt, one due to a person used in civil law. Ancestral debt, one of an ancestor, which the law compels the heir to pay. Now we're talking trust law, right? Case law to support that, Watkins versus Wholesome. Engagements, because that was the language in Article 6. And French law means a contract. The obligation arising from quasi-contract. The terms obligation and engagements are said to be synonymous. But the code seems specially to apply the term engagement to those obligations which the law imposes on a man without the intervention of any contract, either on the part of the obligor or the obligee. An engagement to do or omit to do something amounts to a promise. In English practice, the term has been appropriated to denote a contract entered into by a married woman with the intention of binding or charging her separate estate, or with the stricter accuracy, a promise, which in the case of a person sui juris or dealing with bloodline, will be a contract, but in the case of a married woman, is not a contract because she cannot bind herself personally, even in equity. Her engagements, therefore, merely operate as dispositions or appointments, pro tanto, of her separate estate. Under statute, rendering national bank stockholders liable to assessment in order to discharge an agreement of the bank, discharge an engagement of the bank. The quoted word engagement includes all pecuniary liabilities and obligations of the bank, in case law to support that. The law definition of adoption. The taking and receiving of one's own, that to which he bore no prior relation, colorable or otherwise. Davis versus Land. The act of one who takes another's child into his own family, treating him as his own and giving him all the rights and duties of his own child. Case law to support that. And you see this case law is dealing with a state and Ray Chambers estate, right? Sin, manner provided by and with consequences specified in statute. Fisher versus Robinson. Still dealing with adoption. A judicial act creating between two persons certain relations, purely civil, of paternity and filiation. The relation thereby created is a statutory status, not a contractual relation. Though legal adoption confer on person adopted rights of actual relationship of child, simple adoption extends only to his treatment as member of the household. Shepherd versus Sovereign Camp. See also adopt. Adoption, properly speaking, refers only to persons who are strangers in blood. Case law in Ray Lund estate, another estate case. So you see, everybody got estates. And is not synonymous with legitimation, which refers to persons of the same blood, right? The states passing things down to the heirs, to your son or daughter, etc., dealing with blood. Law definition of Constitution. The organic and fundamental law of a nation or state, which may be written or unwritten, establishing the character and conception of its government, laying the basic principles to which its internal life is to be conformed, organizing the government and regulating distributing, and limiting the functions of its different departments, and prescribing the extent and manner of the exercise of sovereign powers. The charter of government deriving its whole authority from the governed. So the charter comes from the people. Once again, the election process. People saying, okay, you're going to do this. The people feel confident in whoever to do whatever. But the people chose, the people made the election. Case law to support that. In a more general sense, any fundamental or important law or edict, as the novel constitutions of Justinian and constitutions of Clarendon. So once again, the law definition of Constitution. In American law, the written instrument agreed upon by the people of the Union or of a particular state as the absolute rule of action and decision for all departments and officers of the government in respect to all the points covered by it, which must control until it shall be changed by the authority which established it. So if the people establish bylaws, once again, that's the law, so the people dissolve it. And in opposition to which any act or ordinance of any such department or officer is null and void. Law definition of confederation, because that was the language in Article 6 of the Constitution. Confederation, a league or compact for mutual support, particularly of princes, nations, or states. Such was the colonial government during the Revolution. Confederation. Law definition of pursuance, because that was the language in Article 6. A following after or following out line in accordance with or by reason of something comfortable and in accordance, agreeable, conformably, a carrying out or with effect the act of executing, that which is pursuant, consequence, acting or done in consequence or in prosecution of anything, hence agreeable. Case law to support that. Law definition of treaties. An international law. A compact made between two or more independent nations with a view to public welfare. So people from two nations. An agreement, league, or contract between two or more nations or sovereigns, formally signed by commissioners properly authorized, the people, and solemnly ratified by the several sovereigns or the supreme power of each state. A treaty is not only a law, but also a contract between two nations, and must, if possible, be so construed as to give full force and effect to all its parts. Personal treaties relate exclusively to the persons of the contracting sovereigns, such as family alliances and treaties guaranteeing the throne to a particular sovereign and his family, and they relate to the persons they expire, of course, on death to the sovereign or the extinction of his family. So I'm gonna stop it right there. You can pick up from next time. That's about an hour. Turn this recording off.